Hello, hello, hello. How is everybody? How are you? Happy Sunday. Good evening, Europe. Happy afternoon in the US or morning if you're in California. I'm going to say hi to everybody. Hi, Pravit. Hi, Colleen. Hi, Liberty Farmer. Hi, Mrs. Hernandez. Hi, Brenda. Thank you for joining us today. We have a very special guest, so I'm very excited that you're here. So if you're new to the What series, let me tell you a little bit about it. Welcome to the What series, and we appreciate the fact that you took the time to be here today. Now, before we get started, please hit that like button and subscribe and turn on the notification for upcoming lives. So let me tell you a little bit about the series. Christopher Watts never had a trial, which left many questions unanswered as to the tragic events. The What series wants to address some of these questions. The What series is designed as a fact-based and objective series on various aspects of this high-profile murder case based on the discovery, the Weld County files, court document, and public records, through commentary by various professionals and experts. Featured guests have included, for example, prosecutor, a coroner, and a canine expert. The series strives to serve as a platform for mature and serious dialogue in a respectful manner, particularly to the beloved victims, Shanann, Bella, Cece, and unborn son Nico. It does not support the allegations against Shanann in the Watts' first confession on 15 August 2018. So today we will delve into the untelevised plea hearing on 6 November 2018 through a transcript reading and try to answer as many questions as you have about the lead up to the plea, whether it can be overturned. Without further ado, I'd like to welcome you to our guest today. Hello, Eric. Hello, Eric. Can you hear us? Well, let me introduce Eric first. We have the privilege of having a defense attorney today, Eric, who has close to 10 years experience as a criminal defense attorney licensed in 2 states. Eric has worked both in private practice and as a public defender, as well as has trained at a district attorney's office. Eric's practice involves all ranges of felonies, narcotics, domestic violence, attempted murder, and murder. So Eric, thank you for being here. I believe you are still muted. And I cannot, and you have to unmute yourself, Eric, because I can't seem to mute you. Hold on 1 second while we fix this technical difficulty. Okay. So I don't know if you heard me earlier because there's 2 of you in the streams and there's one Eric who is muted. But
Don't know why.
Earlier?
I think I might have logged in twice.
Okay, well, pardon the difficulty. Welcome, everybody, please welcome Eric, and feel free to shoot any difficult questions for him. He just woke up, so I said we're going to be very tough on him today. Eric, so how are you? Okay, looks like we lost him again. So hopefully he will be back soon. If anyone has any questions about pleas, feel free to shoot them now before we go through the plea transcript. We're going to try to address especially some of the rumors in social media, and that's what we'd like to start with and go through the actual plea agreement before we get to the transcript. And that's going to shed a lot of light as to whether or not Chris can have a trial. Hi, Eric. Welcome back.
Hi, Nina. Thank you for having me. I really appreciate it.
Okay, great. Well, thank you. So, Eric, before I gave a little bit of an introduction about you, but would you like to give any disclaimers before we get started?
Yes, that the opinions here are my own. I am not setting out here legal advice to private parties, and that should they have any questions, they should contact a criminal defense attorney in their own jurisdiction. This is for essentially educational and reviewing the file at best. We just want to, explain to the people who and what has happened here, and not necessarily gumshoe the whole issues. Again, there are a lot of questions behind this complex of a case, and I'm only here to help see if maybe we could tether out some answers.
Yes, and also just to be clear, Eric is not a Colorado licensed attorney, although we have looked into Colorado law in extrapolating the 35C. Neither Eric nor I are Colorado licensed attorneys. I am California licensed, and Eric is licensed in 2 other jurisdictions. So we are not qualified to give actual Colorado law advice, although the issues that we discuss and the law are not that different from the jurisdictions that Eric practices in.
And you have to also understand that a lot of the states in the state of the United States have modeled their rules of criminal procedure. And those are the rules that are set out by the Supreme Court of their respective states. And they model them off of the federal rules of criminal procedure. In other words, Rule 35, for example, in the federal rules of criminal procedure, requests for leniency from the court. And at least in the federal jurisdiction, Rules 35 is a request for leniency from the federal judge. Now, what I gather from Colorado is it's a little different, but in federal jurisdiction, only the U.S. Attorney's Office, the Department of Justice, is able to apply for leniency for individuals, and usually those are under circumstances where participating individual has requested this of the federal government, and the federal government then applies on behalf of the defendant. And it sounds like what we have here is Mr. Watts is applying for leniency for himself, but it sounds like we're getting a little ahead of ourselves, and I apologize. But
yes, actually, let's start from the beginning, because I've seen a lot of questions being asked, at least throughout my time in Facebook groups or in YouTube channels. So I thought maybe we would address some of these, and feel free to answer these questions before. Now, in your experience, how many cases that you have handled that resulted in a plea rather than going to trial?
Oh, the vast majority of my cases resolved to a plea agreement. Generally, if there's a significant issue of fact, and that's what the courts are for, they're there for setting a trial, to discuss the fact before a jury of either 6 individuals, which is usually a misdemeanor caliber crime, sometimes 365 days of jail or less, and then 12 individuals in a felony trial for a sentence of a year and a day or more. But the facts of the case at probable cause, which is usually the statement given to the court for signatures for warrants for arrest, or at least for a charging document to have sufficient evidence to have the person brought before court. So once the person is charged, they plea to receive the benefit of the bargain. And had they gone to trial, there may have been consequences that they would have relinquished if they would have accepted the plea agreement. So the vast majority of criminal defendants plea out sometime before trial, or even on the day of trial, which I've had happen to me as well. And so, it saves the court a lot of time, a lot of money. And at the same time, the defendant receives generally a much more lenient sentence had the person had gone to trial and seen some mandatory statutory minimums in terms of prison time or other consequences had they not taken the plea agreement. But I'm hoping that fleshes out one of the reasons why individuals take plea agreements and why the system works so much more smoothly, despite the fact that, generally the gears of justice grind very slowly.
So for the questions about the actual pertaining to Chris Watts, let's hold that off for now. We're going to establish the foundation in general, please. So I know that chat has so many questions, so I don't want to miss questions. Do you see the question that I put on the screen right now? Can when someone speak to an estimate, it would cost the state as well as the defense if a trial were to happen?
Oh, you're asking me, and I presume you know.
This is a question from Liberty Farmer. I don't know if can you read chat?
I'm trying to pull up the YouTube. Do you see the chat
on this side?
I see. Okay, yeah, the comments on the side. I can read. I can view them now. Questions. Is this an older comment, Nina?
It's a comment I put on the screen.
Okay. Now, are we talking about financial savings to the state?
I think the cost of the trial. So it's not the financial saving. It's how much a trial cost. You know how we discussed, for example, how much a death penalty cost, how it costs in the millions because of all the appeals.
Oh, easily.
Now, how much would a regular trial? Let's say more of a murder case, because we're not going to discuss petty misdemeanors here, because those tend never to go to trial. And just for everybody's information, only about 3% of criminal cases go to trial. 90% of them are pled out.
Yeah, the cost is astronomical when it comes to taking cases to trial, particularly high-level cases. For example, murder cases. Any case where the discovery, which is part of the disclosure requirement in the criminal justice system, at least as it pertains to the rules of criminal justice. I think it's Rule 16 in the federal rules. And I'm not sure what the rule for discovery is in the Colorado Rules of Discovery, but voluminous data, disclosures, documents. We could just discuss maybe the medical file of one of the children and the time it would take for a licensed medical doctor to review the file, to review it with counsel, to review it with the police, prepare that individual for trial. And we're talking about hours. We're not, this isn't, the person who is on the stand needs to be able to be prepared. And when asked questions, cannot be asked led questions. In other words, did this happen? Yes. Did that happen? No. Those are leading questions. And so your witness, particularly at a murder trial, needs to be fully informed and needs to be able to resolve certain issues that is presented in court. And so when it comes to the cost of a trial, the savings can be the difference between having a judicial system that's locked in place because every case would end up in trial, or, in Chris Watts's situation, practically resolved within, it sounds like, if a few months, which I found just astonishingly fast, particularly for a triple homicide with 2 children. Is one of those cases that really kind of clutches at my heart because, I get a lot of adult violent crimes, and a lot of them usually revolve around controlled substances. And this isn't one of those type of cases. These 2 children did not, it's terrible what had happened to them. But that aside, yes, the cost of trial is an exorbitant burden on the state and taxpayers. But in addition, if the defendant does take a plea agreement, then that individual saves himself, in addition to the state, significant time. And, if they're in a death penalty jurisdiction like the U.S. District Courts, which is the death penalty jurisdiction if you are arrested by the FBI or any other federal agency and brought to U.S. court, looking at a plea agreement becomes very, very reasonable when they're willing to take that off the table.
Now, we discussed before, actually, in one of our calls, at the first appearance, the defense counsel requested that Chris not be allowed to speak to anybody while in custody. And we discussed how this is pretty common practice because anything the defendant says while in custody can and will be used against him, as phone calls and everything is recorded. Now, can you clarify this, that if this is your practice with defendants that are in custody? Because one of the complaints that Chris Watts' parents had was that they didn't have contact with him. And in fact, they had a person who's not a lawyer write to the judge ex parte a few days before his sentencing that they didn't get to have contact with him because they wanted him to fight the case. So the question is highlighted for you on the screen.
Yes, as a lawyer, is it possible for the prosecution/defense not allow an adult in jail, not yet convicted, not speak with their parents? Now, you know what? This poses, and I hate to pivot from it, but it's important to understand that people in custody who are facing charges are not guilty. Individuals who are charged with crimes are innocent. In fact, even after they plead guilty, they're still innocent. One of the things you can have is a deferred imposition of sentence or some kind of suspended sentence or a stayed sentence. There's even a stay of execution, which is different. but sentence is guilt. And Mr. Watts was technically innocent until the judge handed down the judgment and sentence. So at that time,
I might disagree with you on that. That is true. That his guilty plea, he could withdraw it until the day of the sentencing. I think it states that in the guilty plea when we go through it.
Correct. So, you know, in my advice, at least in private practice and with any of my clients, is to use your Fifth Amendment right. It's a constitutional right. No one can force you to speak against yourself. And when you are talking to loved ones or friends and family members from a correctional facility, they are recording those phone calls. And I can guarantee you this from experience, I hear those conversations. And I can tell you in real time how my heart sinks because they talk about the case and have ruined it before we even walk into court. You know, the confirmation of stories told to one party versus what they tell the police officers can be dramatically different, and it can ruin the plea agreement that you've arranged. It could amend the facts that may be on file that they didn't know about, and it can cause confusion, at least, you know, enough for maybe a plea agreement withdrawal and say, hey, something your client said doesn't add up. This isn't what we agreed to. A lot of bad things happen. I wish I could forbid a client from speaking. They have a First Amendment right, and technically they're not supposed to be there. The only reason why they're essentially there fundamentally is for flight risk or danger to society. And so their bond has to reflect that. For example, if this was a dangerous crime like the one that we're talking about, bond will be high. At least the bail portion, the money value. Bond can be him staying in jail, released without any bond.
Well, yeah, no, he was not granted bail. But I mean, I think the point is that when you're representing a client in custody, you don't want your client talking to anybody because it could completely jeopardize the case.
Oh, absolutely. You're producing witnesses for the prosecution without even you knowing it, because they have absolutely no privilege and confidentiality, unless it's your wife or spouse or another attorney over the phone, or maybe even your priest or religious figurehead, imam or rabbi. There's nothing that protects you. There's no prophylactic that seals your ability to implicate yourself. And more importantly, those statements come in as admissions. They don't come in as a hearsay exception, like business documents or medical documents. You know, it isn't an excited utterance. Oh my God, did you see him run that red light? You know, this is a situation where your client outwardly confesses to a crime and the prosecution has a recording of that person doing it live. And I have been frustrated on multiple accounts where I hear my clients just spill the beans. And I understand that the attorneys want to preserve that Fifth Amendment right, but remember, it's your Fifth Amendment right that you have to be willing to waive. And unknowingly, clients in custody waive it all the time. They pick up the phone or they do a face-to-face Zoom type call from the correctional facility, and you know, the case kind of just it becomes hurt by the discussions that the person in custody gives.
Yes, it's absolutely standard practice, and it's unfortunate because it's been spun over social media due to Chris Watts' parents complaining that they were not afforded the right to speak to their son. But what is I think not really understood is that, they don't have the right to speak to their son while their son is in custody. Is that that there is a reason why counsels do not want their clients to speak to anybody outside of their own attorney, and it is to
All right.
protect their interest.
That's absolutely 100% correct. It's what I advise my clients. Unfortunately, that doesn't, and sometimes I get these phone recordings as an appointed attorney after the fact. They hand me a disc or a thumb drive and they smile. I usually get these documents in the mail, but that being said, it's really difficult to overcome an admission from your client, or at least evidence from your client's mouth that implicates him or her when they're in custody. It's a very trying position to have to be put in as the attorney for the defense client.
Oh, okay. Here, does law enforcement usually end an investigation just because someone pleads guilty? Yes.
Generally, yeah.
The case is closed.
The case is closed. That's correct. Yeah, there's no more putting any more hard work into it. You've got the I'm a student of criminal justice. I have a degree in criminal justice before I went to law school many moons ago. And, I studied how individuals, are implicated in crimes. They take the plea agreement for the benefit of the bargain. They aren't usually either the primary defendant, or sometimes they're innocent. Sometimes they didn't do it at all, and they just they took the plea agreement for their own purposes. I think it was a PBS had a documentary called "The Plea" on individuals taking the plea. But there was no evidence, no discovery, anything in the file that indicated that they were factually guilty. But it's difficult to go backwards in time and essentially, tease out a person's innocence, particularly once they've openly, intelligently, and willingly pled guilty to allegations against them. You waive your rights that you have been represented well if you've had an attorney or appointed counsel. But once the prosecutors have closed the file, the police do the same, and they no longer look for any other defendants, or generally don't need to. So I agree with you 100%. Yeah, I get complaints from a lot of clients saying, well, it was this individual too. That person should have been culpable or more culpable. That was the person who did the most harm. But it's not the job of the defense attorney to prosecute other people's cases. So it's a tough pill to swallow. I understand, but I have been there before.
Yes, and also, the states have limited resources. Let me just ask you, how many cases did you have on your load of cases when you were a PD, when you were a public defender at a time?
Oh.
Because it ranges from traffic. Yeah, people don't sometimes realize that it ranges from like traffic ticket cases to serious felonies.
You're appointed counsel only if there is a risk of incarceration. So, speeding ticket or a parking ticket, you're not going to get an appointed counsel to. But,
okay. But DUI, you would.
A DUI is a misdemeanor, and it's a very serious charge in a lot of cases, because people are at risk. Their life is threatened when somebody, has a couple drinks, gets behind the wheel, and then blows above, the statutory limit, which is usually 0.08. And when people blow on 6, double the legal limit, that's an aggravated. And that is serious because your facilities are incredibly impaired. That being said, volume. I remember at one point I took a look at my case file. This was one point when I was with the public defender's office. I had 230 cases. And I mean, this was kind of just me with my file load at the time. And yeah, it's astronomical. It's not a lot of time to handle, so many files. But it sounds like that wasn't the case with Mr. Watts. He had counsel, and they were very attentive. And generally, with these type of cases, it's paramount on their. This isn't a DUI case, in other words. This is a homicide.
It was, and we'll get to that in a second. But yes, I remember when I interned at the DA's office and I shared an office with 2 assistant district attorneys. That was in San Francisco, and each of them had 200 cases or so on their docket. And I mean, they were working around the clock. So it is a very, very tough job in terms of caseload. And so, I mean, to answer, think for yourself question about after there's a guilty plea and sentencing, there's no more investigation, because you also have to think about the state funding and resources of law enforcement as well.
Hand in hand, once again, it's the state paying money for itself to protect citizens, but at the same time for defense attorney when appointed counsel is required by law. No. It's a U.S. v. Gideon issue. So regardless of whether Mr. Watts can afford attorney or not, he has the absolute right to an attorney. That's a U.S. v. Gideon case.
I think the point I was making, though, Eric, it was a separate point, is that once a case is closed, there's no more investigation, because you also have to consider the state's budget and resources to be doing an investigation on a closed case.
Oh, it's a waste of time. It's a waste of time. It's a waste of money and resources, and for them, it's a waste of time. There are what people would call cold cases because the police have given up on the investigation of the case they deemed closed. Other people might have opinions, but it is really at the discretion of the individual sheriff's offices, which are political appointees, or at least elections. And also then the prosecutors have to manage the case that is being enforced by the police. So yeah, once they get their defendant, once they get the conviction, yeah, they stop, they close the case. I've seen that multiple times. Yeah, you're right.
So Colleen asked, so Eric, have you heard about the case before? You were contacted to look into this case. Have you heard about the Chris Watts case before?
I've heard about it tangentially. It's in the ether of the criminal justice system. But I never delved into so much detail until you contacted me. The voluminous discovery, the proceedings, as limited as they were, there still was documents. There's also transcripts. Every time you speak in court, there's a lady in the corner. She's typing everything you say. Her name is the court reporter or recorder, and you're on the record. When they say that, that means that there's literally somebody taking down what you say on the record. And that's one of the only few things that an appeals court would see. They're not going to see the people. They're not going to see all of the attorneys or even the district court judge. The only thing they're going to see is the record, all the filings, and then, of course, the transcript. So, I've had to be smart quick on this case. And it's a tough case because, there are a lot of things that are people questioning, but after reviewing the file, the state came to its conclusion. Mr. Watts took responsibility, and now the file is closed, at least in terms of the state of Colorado's position.
And one of the questions that was raised was about Chris not having, okay, the first one is about why wasn't Chris drug tested upon his arrest, and why was he not given a psych eval? Can you address these?
Sure. Let's start with question number one. In chemical dependency cases, individuals who are arrested with chemicals, for example, controlled substances, those individuals have a priority of being tested first. Now, it doesn't make very much sense unless there's some kind of probable cause to have a warrant issued for his blood and or urine. The U.S. Supreme Court has taken state of North Dakota and Minnesota on that issue when it comes to DUI breathalyzers and also blood. Now, a breathalyzer, you don't need a warrant for it, but there also has to have probable cause to stop the individual. And then, of course, some kind of triggers or clues, I think it's 6 of 6, to figure out whether you have been driving under the influence. Once again, it's these safeguards so that the state or the government doesn't intrude on your private constitutional rights. So if they're gonna issue probable cause that he was under the influence for some reason, then they would have a reason to issue a warrant to either get his blood, breath, or urine. Now, he wasn't caught driving under the influence. This isn't a chemical dependency case, and this is also not a controlled substances case. So those issues in terms of controlled substances, either in his system or while they were affecting him, aren't exactly applicable. There was no signs of him like he had been
Being incapacitated.
Right.
I think we watched the polygraph together and the confession video together, which started from 11 a.m. and I don't think he was arrested until 6 p.m. and he didn't show any signs of being under any substances. And I think he was asked questions to that effect before the polygraph as well.
Right. And, when they do take the plea, they got to make sure that they ask certain questions. Just, are you being threatened? Are you clear-headed? Has anybody other than the state offered you anything in return for your plea of guilty? So since there wasn't a real issue of controlled substances, now we turn to, did he have capacity to understand the charges against him? Now, generally, if for example, the attorneys cannot communicate with him or he doesn't understand the charges against him, now we have an issue of capacity. Does the person understand the capacity or have the capacity to understand the charges against him? Because the first step would be to restore his capacity if they can. Now, Mr. Watts never really had an issue, as I could tell from the dash cam or body cam videos. He's trying to explain to them, where she is, what has happened. He seems like he has capacity. I'm a layperson when it comes to medical field. I'm not ever going to pose myself as a psychologist or psychiatrist. But generally, that's prima facie case to say that this person seemed lucid. If they wanted to test Mr. Watts out just to kind of there's a fail safe, they could have brought in a psychologist or psychiatrist, but I didn't really see that issue being raised by either prosecution or defense counsel. Defense counsel should have filed the motion and said, hey, Mr. Watts is, barking at the moon. That would have been a fantastic defense, but that never happened. And there's nothing in the record that indicates to the contrary. So when he's asked questions by the judge or, during communications with counsel, that no time did it seem like there was an issue of capacity being raised. So, yeah, a lot of people may think he is mentally disturbed, but that's a judgment called by a professional. And I always defer to my experts. They know a lot more than us, and we can't make the decision on their own. I wouldn't want to say that somebody's dying from cancer because I'm not an oncologist. Those individuals go to undergrad, medical school, internships, residencies, and I would leave the judgment of the oncologist on whether somebody has cancer or not. But in this particular situation, Mr. Watts never had any of the telltale signs or evidence that supports some kind of finding of fact that he had lack capacity or that he had some kind of mental illness. So, that's not an issue that I would think he could raise on appeal, or an issue that he even defended with to begin. But, that's kind of where we're at now. We're at the end of this saga. And so going backwards in time and saying, well, why didn't we have this happen? Why it didn't happen? Because there was no car, there was no alcohol in the system. There was no, it's not that type of case.
Got it.
Yeah, thanks.
So why don't we move on to, I think the crux of the live today, which is, can Chris get a trial? And before we get to the plea hearing transcript, which is going to answer a lot of that question, I'd like to open the 35C form for the viewers to see what are the grounds for the post-conviction relief in Colorado. And then we'll look at the plea agreement, and then we'll go through the transcript as to exactly what happened, since that hearing was never televised. So we can go on any YouTube channel to see exactly what happened and what Judge Kopkow asked Chris, and whether or not that plea can essentially now be attacked. So why don't we first, what I'm going to share is the 35C, hold on. Let me just find that document.
This is a petition to ask for leniency of the court, or to have his...
it's post-conviction relief.
Right. Now, did we want to talk about that at all?
Well, I think what we need to do is just show the form and
Sure.
And the grounds. Hold on. Let me just make sure that I have the right.
Well, just for your audience members, could I give you a primer on the post-conviction relief? And this comes from their from the standard language, but the post-conviction relief is when a defendant who has now been convicted of a Colorado crime asks the court to vacate the judgment or sentence. It's also called the 35C motion. Post-conviction relief grants defendants an opportunity to argue why his or her verdict or sentence was invalid. Generally, in 35C cases, the sentence may be invalid, or in some jurisdictions, alternatively, it could be a reduction of sentence. In the federal rules of criminal procedure, Rule 35C or 35 can only be motioned by the U.S. Attorney's Office or Department of Justice, DOJ. The defendant has no right to file a 35, and that would be either to amend the sentence or to have the sentence vacated or judgment sentence amended. And it's similar to some state courts, particularly ones that I practice in. As for Colorado, it sounds like this is a post-conviction relief. This is after his appeals have all been exhausted or waived at this point. From what I gather, there was no motions to appeal, and so or a petition to appeal to the Supreme Court of Colorado. So his post-conviction relief is based off an opportunity to vacate the judgment or sentence and look for a verdict to be lifted on some grounds. And generally, ineffective assistance of counsel is the one applicable in a post-conviction relief. What that means is that essentially your attorney didn't do a good job. And as you pull up the document and the record, it'll probably clearly illustrate that Mr. Watts' attorneys did the best that they could considering the circumstances, and that the record will clearly indicate that, they asked him the questions directly. Do you understand the plea agreement? Are you a clear head? Are you giving your plea freely, willingly, and intelligently? Has anybody threatened you or given you anything other than this plea agreement to plead guilty to this? And I think and I'd hate to kind of step forward with this, but there was talks about, different facts to the case as it came to, what had happened to the children. And I'm not going to end up in spoiler alerts here, but, the things that the children's case seemed different at first, but Mr. Watts pled guilty to all 3 homicides. So
okay. Well, we'll go through the plea agreement in a second. Eric, can you please check your message, by the way?
Yeah, sure.
Okay, so let me just make sure you can see this on the screen with me. So this is the 35C form that Chris would have to fill out, or his attorney would have to fill out. And okay, let me just. So basically, actually, Chris doesn't even need an attorney. He can fill this out himself. And it's a 4-page form that is quite simple. And he'll just tick the box as to whether or not it was a plea, a jury trial, or a court trial, and whether or not he was represented by an attorney. And then he'd have to list his attorney, and whether or not the case was appealed. Now, this is very unusual because 35Cs are usually done after an appeal and after a jury trial. So it's very unusual when there's a 35C after a plea agreement. Chris had 47 days to appeal his plea, which he did not. And the post-conviction relief is here. He would have to fill out his name, the nature of the proceedings and the claims raised. And he can actually request for counsel. So this discussion right now that whether or not counsel can be afforded, he can actually petition as an indigent and request a counsel to do this. And then he would have to state the claim. And when you go to this page, these are the grounds for the 35C. So the conviction was obtained, or the sentence imposed was in violation of the Constitution of the United States, or the Constitution of the law of the state. So we would be looking at the 4th Amendment against unreasonable search and seizure, which doesn't really apply in this case because all of the searches of Chris Watts' house and everything was done either through consent or with a warrant. The 5th Amendment, well, Chris basically waived his 5th Amendment by talking to the police right away and never requesting counsel. He also signed his he was also given a Miranda warning, and he signed that he understood all his Miranda rights. And then the Sixth Amendment is the right to jury trial, and he waived that with his plea agreement. And the other ground is the defendant was convicted under a statute that is in violation of the Constitution of the United States or of Colorado. Now, we don't have any reason to believe that. The court rendered a judgment without jurisdiction. We don't have any reasons to believe that. There exists evidence of material fact, not therefore presented and heard, which by exercise of reasonable diligence could not have been known or learned by the defendant or his attorney prior to the submission of issues to the court or jury, which requires vacation of the conviction or sentence. Now, this would be evidence that Chris didn't know, rather than, and I mean, as far as we know, there was not any evidence that was withheld from Chris. And any other grounds? And the sentence has fully been served. So with the Sixth Amendment, right to jury trial and right to counsel, he can also claim ineffective assistance of counsel as one of the bases. Now, I am going to stop sharing the screen, and we are going to look at the plea agreement very quickly. Or actually, we should go straight to the plea hearing before looking at the plea agreement. Eric, are you still there?
I am.
Okay, so let's go straight to the... In terms of timeline, Chris had the preliminary hearing scheduled for the 19th of November, and he waived the 35-day statutory mandatory preliminary hearing at his... Eric, it's very loud. Hey, Eric.
Yes.
Can you please turn down the volume?
Oh.
Hello?
Yeah, you can hear me, right?
Yeah. There was a sound of clinking, and I'm not sure, but so the 19th of November was the date for the preliminary hearing, and that is where the prosecution would show probable cause to stand trial. The bar is pretty low. They just have to show that there's just sufficient evidence to go forward, and in that circumstances, probably Detective Baumhover would be testifying. And do you have anything to add to that, Eric, in terms of the preliminary hearing?
Essentially, the preliminary hearing is a probable cause statement. Is there sufficient evidence here to arrest the person? In a misdemeanor case, generally, it's sufficient to have a citation. But in a felony, you're capable of cross-examining the officer testifying against you. It's a similar situation with a grand jury, except that's done in private. And this is also the same level of evidence. It's a probable cause standard, which is really just one of the lowest standards in law. And he not only waived the timeline, the 35-day statutory mandatory minimum, unless you waive it, I believe he also waived the preliminary hearing, which...
Well, he waived the 35-day period. That's why instead of it, his first appearance was on the 16th of August, and on the 22nd of August, he waived the 35-day statutory limit. He didn't waive his preliminary hearing altogether. So it was meant to be scheduled on the 19th of November. And what happened was on the 2nd of November, both counsel, the prosecution, and the defense attorney requested a status conference for the 6th of November. Eric, do you see the comment on the screen?
What's that? Which comment? Oh, yeah, I see that. Yeah.
It's still early for Eric.
It is. It's on a Sunday too. But I'm glad to be here. I'm glad to participate in this. It's a big case. It's a sensitive case too because of the people involved, and it's just I'm only hoping I can help out and get some information for you and your the file essentially you're presenting here. So yeah, I apologize. I didn't meet my cup.
No, we're just joking here. You get the next comment. We're just joking with you. We're being friendly.
I understand.
We want to make sure you come back.
That's okay.
I know you're always a good sport. I've known Eric for how many years now?
25, I think.
Yeah, I've known Eric for 25 years, so it's okay. I can give Eric a hard time.
Yes, you have. It's part of the course, and since we're both attorneys, you sometimes have to have a thick skin in this industry. So,
so we're going to go through what happened at the status conference that day, and I think Eric, you're going to play the role of Judge Kopkow, and I will be Chris Watts, or Stephen Wren, or John Walsh. And Stephen Wren is the assistant district attorney, and John Walsh is the lead public defender representing Chris Watts. So can you see on the screen, Eric, and can everybody in chat see now?
Yeah, but you're going to have to pull that the document up a little bit because all we see is Christopher Lee Watts and defendant.
Yeah, so let me pull down the document.
Well, you're welcome, Lola. Okay. Thank you for the comment.
So the people versus the state of Colorado. The people of the state of Colorado versus Christopher Lee Watts for the court use only, case number 18CR2003. For the people, Michael Rourke, Stephen Wren, Patrick Roach. For the defendant, John Walsh, Catherine Harold. November 6, 2018. Status conference, change of plea. The matter came for hearing before Honorable Marcelo Kopkow, Judge of the District Court. The defendant was personally present. So I think you can take it from here, Eric. You're the court.
Good afternoon. You're welcome to be seated. Okay, we're on the record. It's November 6, 2018. It's 2 o'clock. We are in Division 17 of the Weld County District Court. My name is Marcelo Kopkow. I'm a district court judge here in Weld County. Last week, the parties requested that we set this matter for a status conference. And before we get involved in the discussion, if I could please have the lawyers identify themselves for the record.
Mr. Wren, Stephen Wren, Michael Rourke, and Patrick Roach appearing on behalf of the people.
Thank you.
Mr. Walsh, Your Honor, John Walsh and Catherine Harold on behalf of Mr. Watts.
Thank you. Mr. Wren, would you like me to? No, that's the court speaking. Thank you, Mr. Wren. Would you like to ask? Would you like me to ask you questions for the prosecution?
Mr. Wren, Yes, Your Honor.
In the court, did you want to make a record regarding compliance with the Victims' Rights Act?
Yes, Your Honor. As I believe this court is fully aware, we have reached an agreement and we're prepared to present that to the court today. We're in compliance with the Victims' Rights Act. Specifically, we have present in the courtroom the family of Shanann Watts and the children. First row, we have Frank Rusek, Sandy Rusek, and Frank Jr. Rusek. They are present from North Carolina. And I can represent to the court at this point that they are in full agreement with the terms of the agreement that we will be presenting to the court shortly.
Thank you. And did you want to present the paperwork to me?
Mr. Wren, if I may approach?
Sure. Let me make sure a comment first. I apologize for not having a big enough courtroom. This is the only available courtroom that has this size. Others are smaller. So I apologize for those of you who feel a bit cramped. There's also a seating capacity in the courtroom. Let me also state it's pretty obvious that this case draws a lot of emotions with people. I expect that everybody who's in the courtroom act accordingly. If your demeanor is not consistent with that, that's required in a courtroom, you're going to be asked to leave. So please be mindful of that. Mr. Watts, it's my understanding that you have reached an agreement with the prosecution. Is that correct?
Mr. Watts, yes, sir.
Okay, can you give me 1 second to review the paperwork? So, Mr. Watts, I'm going to be discussing this paperwork with you. If at any time you have any questions, comments, concerns, it's really important that you let me know. Do you understand?
Mr. Watts, yes, sir.
So it's my understanding that you're going to plead guilty to all counts set forth in the complaint and information. Specifically, you're going to plead guilty to count 1, murder in the first degree, a class 1 felony as relates to Shanann Watts. You're going to plead guilty to count 2, murder of the first degree after deliberation, a class 1 felony as relates to Bella Watts. You're going to plead guilty to count 3, to murder in the first degree after deliberation as it relates to Celeste Watts, a class 1 felony. You're going to plead guilty to count 4, murder in the first degree with a child being under the age of 12 as it relates to Bella Watts, a class 1 felony. You're going to plead guilty to count 5, murder in the first degree, the child being under 12 as it relates to Celeste Watts, a class 1 felony. You're going to plead guilty to count number 6, unlawful termination of a pregnancy in the first degree as it relates to Nico, class 2 felony, and you're going to be pleading guilty to counts 7, 8, and 9, tampering with a deceased human body, a class 3 felony. Is that right?
Mr. Watts, yes, sir.
And it's my understanding as it relates, is it solely to count 1 that is an act of domestic violence?
Mr. Wren, yes, that's correct, Your Honor.
Thank you. The plea paperwork furthermore states that all sentencing options on all counts are open to the court. However, in exchange for your guilty pleas, the office of the district attorney agrees that it will not seek the death penalty. Whether the sentencing on separate counts run consecutively or concurrently to each other is open to the court, with the exception that at minimum, the parties stipulate that sentencing on count 1, 2, 3, and 6 shall run consecutively, as each charge references a separate victim. Do you understand that?
Mr. Watts, yes, sir.
Do you understand what the word consecutive means as opposed to the word concurrently means?
Mr. Watts, yes, sir.
Your lawyers explained that to you.
Mr. Watts, yes, sir.
The plea paper continues to state that you will not be permitted to waive a factual basis for any charge. Do you understand that?
Mr. Watts, Yes, sir. Now, I just want to pause right here that this is very important because this means that Chris cannot later on change the facts of the case. In other words, he can't then, if you waive, he's saying that he's agreeing to the facts of the case, that he is stipulating that he agrees that there's sufficient evidence that he committed the crime. Okay, let's proceed.
Okay, the court. The plea agreement goes on to state the parties further stipulate that the defendant will pay restitution as determined by the courts, including but not limited to the expenses for funeral and burial expenses for Shannon Watts, Bella Watts, Celeste Watts, and Nico Watts. Furthermore, you are agreeing to pay restitution covering the actual costs of specific future treatment pursuant to 18.1.3-603, parent 1, parent C. Do you understand?
Mr. Watts, yes, sir.
The plea agreement goes on to say that the parties are stipulating that the prosecution may withdraw from this agreement if you commit a new felony offense while awaiting sentencing, which will not be today. Do you understand that?
Mr. Watts, yes, sir.
Do you have any questions about anything I have said so far?
Mr. Watts, no, sir.
Mr. Watts, can you tell me your highest level of education?
Mr. Watts, technical college.
So you graduated from high school, then went to technical college.
Yes, sir. And let's just pause right here. Here, the judge is establishing his basic level of knowledge and education to make sure that Chris has a level of capacity to understand and fully appreciate the charges and what he is pleading to. Eric, do you have any other comments?
Yeah, that his level of competency is high enough that he understands. He's a high school graduate, which puts him at a certain level, at least in terms of his ability to understand the proceedings that are before him. It's one thing for Mr. Watts to say yes, sir, and another thing for him to also supplement the factual basis that he has a high school degree / technical college education.
And what I forgot to explain earlier is that the plea hearing, the judge will engage in this colloquy, which is a line of questioning to make sure that Chris is pleading voluntarily, knowingly, and that he is not coerced, and that he understands and appreciates all of his charges and what he is doing, and that he is satisfied with his counsel's assistance. And this is very important. All of these questions are extremely important, and they have to be entered in for the record. And that's why there is a transcript, so as to avoid buyer's remorse. Because typically, inmates, when they're in jail, first they find God, and then 2 years later, they want to get out. Right, Eric?
Yes. Nobody wants to go to jail or prison. I understand. And yeah, it's a difficult position to be placed in. And I've had several individuals upset that they've found themselves there. And, they wish the circumstances were different. Nina, I think there was, lines 14, 15 that was pushed out of frame a little too quickly. I didn't mean to.
Oh, yes. No,
there
thank
it is,
you.
right there.
Thanks for letting me know.
The plea has to be done knowingly, willingly, and intelligently. And by being a high school graduate, by being a person with technical college skills, he is more than intelligent enough to understand the colloquy between himself and the judge. And the judge has already established that by asking his high school education, level. So there has been in the past, there are individuals who have no education, and some individuals who have never been able to gone to school because of they didn't have the capacity for it. So that by the court asking Mr. Watts specifically, did you have a high school diploma? And then in addition to that, do you have anything past that? He said, yes. I mean, he's an intelligent guy. He understands, a lot, sufficient for the judge to ask him these technical questions. And I understand that they're legal questions, and he's a layperson, but that he has the intelligence to understand them, not only the willingness and the knowledge of what he is getting himself into. Should I continue reading for the court?
Yes, please do.
Okay. Yes, the court. Do you have any difficulty reading and or understanding the English language?
Mr. Watts, no, sir.
Do you have any opportunity to review the written waiver on guilty plea?
Mr. Watts, yes, sir.
The first page explains.
Mr. Wren, Your Honor, if I may, I would also point out that on the bottom of the second page, we took the unusual step of having the district attorney sign the plea agreement, given the nature of the plea, and specifically the fact that we were removing the death penalty from consideration.
Thank you. So the first 2 pages explain all of the rights that you have and the rights you are giving up. Do you have any questions about these rights?
Mr. Watts, no, sir.
Any questions about the terms or concepts or definitions of any of these words?
Mr. Watts, no, sir.
Did you have sufficient time to discuss these very important rights with your lawyers?
Mr. Watts, yes, sir.
And are you completely satisfied with the assistance of your attorneys?
Mr. Watts, yes, sir.
Do you believe that you've spent sufficient time discussing these rights with them?
Mr. Watts, yes, sir.
Do you believe that you've discussed different strategies and defenses and gone over all of your discovery with them to your satisfaction?
Mr. Watts, yes, sir.
Did they answer all of your questions to your satisfaction?
Mr. Watts, yes, sir.
To date, is there anything that you believe that you should have done that they have not yet done?
No, sir.
So again, you are completely satisfied with the assistance of your attorneys representing you in this case?
Yes, sir. Boom. So that basically nails all of the ineffective assistance of counsel argument on the record. Should Mr. Watts now try to challenge it? Eric?
It's the reason why those foundational questions are asked at essentially every single plea agreement in one fashion or another. Generally, when you have a long line of misdemeanor cases, you need to discuss these rights with every single one of these defendants if they decide to plea. This being a high-profile murder case, it's paramount that these issues have to be raised right away. And more importantly, that he not only knows, that he's willing, and he is intelligently accepting that. And when it comes to his post-conviction relief, essentially the ineffective assistance of counsel claim would look at least this portion of the transcript that we read together, and the Supreme Court would have a very difficult decision in trying to overturn the decision of the district court to find him guilty.
Well, the post-conviction relief actually goes back to Judge Kopkow. So he's going to go back and read the transcript and be like, "Nuh-uh, I've already asked you all of these questions on the record. Let me pull up my transcript."
Yeah, and the thing is that I mean, generally on an appeal, even if it was before the same judge, he would review the record and say, you know, I did what I needed to do. And yeah, I think someone said, you know, it seems a little repetitive, but it's prophylactic from different angles. It's that willingness, that knowledgeable, that's intelligent, and more importantly, that all of the issues in terms of what goes on in the case, you know, the review of discovery to the satisfaction of not only the attorneys but also the client. You know, you're waiving all those rights. It's a Sixth Amendment right to confront the witnesses against you, and you're giving that all up for this plea agreement. Now, if you remember at the beginning of this, part of the plea agreement is they remove the death penalty off the table, and that's huge. That's paramount. Yeah, I don't know what. I think they ended up lifting the death penalty in Colorado, but that's a long road for individuals who find themselves in those positions. Yeah,
Yes,
it's a tough case.
And we'll discuss that in a second. But I think if you see the transcript, you'll notice that the judge tries to phrase and rephrase the question in every possible way so that there is no getting out of ineffective assistance of counsel. Was there anything that they could have done differently? Did they go through the discovery with you? So now every rumor that you're hearing in social media about possible ways that Chris didn't get the discovery or his counsel didn't do that, or all of the things that you're hearing,
No.
he stated very clearly on the record.
Yeah, and it doesn't matter the evidence outside that people are bringing up. It's what matters is what happens in court and on the record. And unfortunately for Mr. Watts, he did state before the judge on the record that he was satisfied, and there's kind of, you can't unring that bell. So he's kind of stuck with the situation he put himself in. You know, that's why attorneys make sure that they have to go over these rights and, you know, make sure that they understand what they're doing before they go in there. You know, can't have buyer's remorse, particularly to the attorney.
Well, I mean, the judges take guilty pleas very, very seriously. And if there's any scintilla of doubt by Judge Kopkow, he is not going to accept the plea.
No, absolutely not. If there's any hesitation, if somebody doesn't speak English well enough, you know, if somebody doesn't understand certain terms, there is no acceptance of a plea. Absolutely not. No judge, you know, a good judge would accept the plea. I've been in situations where, you know, my client has accepted the plea agreement, has signed documents, and then when it comes to the factual basis, you know, starts to flounder, and the judge looks at both parties and says, I can't accept the plea. And we're right back where we started, and we may even end up losing our plea acceptance window, which sometimes they set out. And so in this particular case, you know, they asked him, and they asked him over and over and over again in different fashions, covering different aspects. You know, do you speak English? Did you go to high school? Do you know what day and time it is? Not that capacity was an issue here or was ever necessarily raised by either party. He answered the questions succinctly, and I think the record is clear that he was satisfied with counsel. And just a quick aside, when you hire an attorney or when you are appointed defense counsel, you are giving over that case to defense counsel. And that individual is now responsible for your liberty and your life in this particular case. And more importantly, the layperson doesn't have, 4 years of undergrad, 3 years of law school, a grueling bar exam, licensure, continuing learning educations, and years of practice under their belts in a certain circumstance, like, for example, criminal law, for example, or felony homicide defense. So you have to trust your attorney. And in this case, Mr. Watts felt very, very comfortable enough in front of the judge to uninhibitedly say, yes, they did a good job. I accept their due diligence, and I accept this plea agreement for its offer. And that's paramount. I think that's what's being said underneath the lines that are written in the text. The questions say one thing, but behind that, behind the scenes, is a lot of work that comes together before individuals walk into court and are asked these questions back and forth. And yeah, we just ate up a lot of time talking about this, but you understand that the hearing in and of itself was probably like 20 minutes long. And then in addition to that, there was probably hours and hours, if not days and weeks, because there wasn't a lot of time in this particular case preparing Mr. Watts for his plea hearings. Did he want to do this or not? And then if he did, you understand the file if we took this to trial, So, I mean, I understand you want to focus on the 35C.
Yes, well, let's finish. And we may not have to read everything in the transcript because some of it is repetitive, but let's go through it. Okay, so I think the next is line 8. And then we can take the viewers' questions from there and have a general discussion.
Continue?
Yeah. Yes, please.
Yes.
Counsel.
The court. Well, I play the court. This is the first time. Thank you, by the way. I appreciate it. Let me just read. The court. Is this your signature that appears in the black and blank ink on page 2 of my copy?
Mr. Watts, yes, sir.
The next pages of paperwork explain the legal definition. Actually, it's the next 3 pages explains the legal definition of the crimes that you're pleading guilty to. If these charges proceeded to trial, it would be the prosecutor's burden to prove each of these charges to a jury of 12 unanimously, beyond a reasonable doubt before you can be convicted of these crimes. Do you understand?
Mr. Watts, yes, sir.
Any questions about the legal definition of the crimes that you are pleading guilty to?
Oh, hold on one second.
Mr. Watts says no, sir.
No, sir.
The court, 1 second, just to review this paperwork. Mr. Ween, maybe I'm missing it. Ren, I apologize. Where is the definition of domestic violence and intimate relationship in the paperwork?
Mr. Wren, it's not in there, Your Honor.
Mr. Walsh, would you like me to advise your client of the legal definition of the crime? Excuse me, of the definition of domestic violence and intimate relationship?
Mr. Walsh, Your Honor, we've been over that, but I'd leave it in the discretion of the court.
So, Mr. Watts, one of the allegations of the complaint is count number 1 is an act of domestic violence. There is a legal definition to domestic violence, as well as intimate relationship. Did your lawyers explain to you the legal definition of domestic violence and intimate relationship?
Mr. Watts, yes, sir.
Do you have any questions about the legal definition of domestic violence and intimate relationship?
Mr. Watts, no, sir.
Would you like me to again advise you of the legal definition of domestic violence and intimate relationship?
Mr. Watts, no, sir. My lawyer went over that with me.
I didn't understand what you just said.
Mr. Watts, no, sir.
The next page explains the possible and to some extent the mandatory sentence for the crimes that you're pleading guilty to. So let's just go over that together, okay?
Mr. Watts, okay, yes, sir.
So with regard to counts 1, 2, 3, 4, and 5, murder in the first degree, the minimum mandatory sentence that the court would be required to impose is life in prison without the possibility of parole. Do you understand that?
Mr. Watts, yes, sir.
With regard to the unlawful termination of a pregnancy in the first degree, a class 2 felony that carries a prison sentence of 16 to 48 years confinement in the Colorado Department of Corrections, followed by an additional mandatory parole period of 3 years. Do you understand that?
Mr. Watts, yes, sir.
And there's a potential fine between $5,000 and $1 million. Do you understand that?
Mr. Watts, yes, sir.
With regard to count number 7, 8, and 9, those are each class 3 felonies that carry 4 to 12 years in the Colorado Department of Corrections. If there were sufficient mitigating circumstances, the court may reduce the minimum sentence to 2 years. If there were sufficient aggravating circumstances, the prison sentence may be increased to as many as 24 years, and any prison sentence would be followed by an additional mandatory parole period of 3 years. Do you understand that?
Mr. Watts, yes, sir.
That also carries a potential fine of $3,000 and $750,000 per crime. Do you understand that?
Yes, sir.
Any questions about the possible penalties?
No, sir.
This afternoon, are you under the influence of alcohol or drugs or any other medications or substances, legal or illegal, that affect your ability to think clearly?
No, sir.
Has anybody put any pressure on you or forced you or threatened you to do this?
No, sir.
Are you doing this of your own free will?
Yes, sir.
Do you have any questions that the court can answer for you with regard to the rights you have, the rights you're giving up, the possible penalties, and what the plea agreement is in this case?
No, sir.
Knowing everything that we have discussed, I'm going to now individually ask you how you wish to plead to each count. And I'm going to read from the charging document. Count number 1, again, alleges murder in the first degree, a class 1 felony, and alleges that on act of domestic violence on or about August 13th, 2018, Christopher Lee Watts unlawfully, feloniously, after deliberation and with the intent to cause the death of a person other than himself, caused the death of Shannon Watts in violation of 18-3-102, subsection 1, subsection A. How do you wish to plead to that count?
Guilty.
Excuse me?
Guilty.
Count 2 alleges murder in the first degree of class 1 felony, and it reads between and includes August 12th, 2018 and August 13th, 2018, Christopher Lee Watts unlawfully, feloniously, after deliberation and with the intent to cause the death of a person other than himself, caused the death of Bella Watts in violation of section 18-3-102, subsection 1, subsection A of the Colorado revised statutes. How do you wish to plead to count number 2?
Guilty.
Count 3 alleges murder in the first degree, a class 1 felony, and it reads between and including August 12th, 2018 and August 13th, 2018, Christopher Lee Watts unlawfully, feloniously, after deliberation and with the intent to cause the death of a person other than himself, caused the death of Celeste Watts in violation of section 18-3-102, subsection 1, subsection A of the Colorado revised statutes. How do you wish to plead to that count?
Guilty.
Count 4 alleges murder in the first degree, a class 1 felony, and it reads between and including August 12th, 2018, August 13th, 2018, Christopher Lee Watts unlawfully, feloniously, and knowingly caused the death of Bella Watts. A child had not yet attained 12 years of age, and the defendant was in a position of trust with respect to the victim in violation of Section 18-3-102, subsection 1, subsection F. How do you wish to plead to count number 4?
Guilty.
Count number 5 alleges murder in the first degree, a Class 1 felony, and alleges between including August 12, 2018 and August 13, 2018, Christopher Lee Watts unlawfully, feloniously, and knowingly caused the death of Celeste Watts, a child who had not attained 12 years of age, and the defendant was in a position of trust with respect to the victim in violation of 18-3-102, subsection 1, subsection 4 of the Colorado Revised Statute. How do you wish to plead to count number 5?
Guilty.
Number 6, unlawful termination of a pregnancy in the first degree, a Class 2 felony. The charge reads, on or about August 13, 2018, Christopher Lee Watts, with the intent to terminate unlawfully the pregnancy of a woman, namely Shannon Watts, feloniously and unlawfully terminated the pregnancy of the woman. Further, the woman died as a result of the unlawful termination of the pregnancy in violation of 18-3.5-102, subsection 1, subsection 2 of the Colorado Revised Statutes. How do you wish to plead to count number 6?
Guilty.
Count 7 alleges tampering with a deceased human body, a Class 3 felony, and it reads, on or about August 13, 2018, Christopher Lee Watts, believing that an official proceeding with pending, in progress, are about to be instituted, and acting without legal rights or authority, unlawfully and feloniously, willfully destroyed, mutilated, concealed, removed, or altered a human body, part of a human body, or human remains, with the intent to impair its or their appearance or availability in official proceedings, in violation of Section 18-8-610.5 of the Colorado Revised Statutes. How do you wish to plead to count 7?
Guilty.
Count 8 alleges that on or about August 13, 2018, Christopher Lee Watts, believing that an official proceeding was pending, in progress, or about to be instituted, and acting without legal right or authority, unlawfully and feloniously, willfully destroyed, mutilated, concealed, removed, or altered a human body, part of a body, human body, or human remains, with the intent to impair its or their appearance or availability in the official proceedings, in violation of Section 18-8-610.5 of the Colorado Revised Statute. How do you wish to plead to count number 8?
Guilty.
Count number 9 alleges tampering with the deceased human body, a Class 3 felony, and it reads that on or about August 13, 2018, Christopher Lee Watts, believing that an official proceeding was pending, in progress, or about to be instituted, and acting without legal rights or authority, unlawfully and feloniously, willfully destroyed, mutilated, concealed, removed, or altered a human body, part of a human body, or a human remains, with the intent to impair its or their appearance or availability to the official proceeding, in violation of Section 18-8-610.5. How do you wish to plead to count number 9?
Guilty.
Mr. Watts, excuse me? Mr. Wren or Mr. Walsh, is there going to be a factual basis that was going to be presented to the court?
Mr. Wren, we would leave that up to the court's discretion as to how to proceed with that.
Mr. Walsh?
We would stipulate to the factual basis, Judge. Now, Eric, can you explain what this means? That the defense is stipulating to the factual basis, and that because in the sentencing, they did not allocute.
Well, essentially, there has to be sufficient facts to support the charge. Essentially, at this point, there's only just an allegation. Yeah, it does sound pretty heinous, but at the same time, the charges are just an allegation of what possibly could have happened. The factual basis will be the specific events that had happened that made the charges essentially fleshed out. So generally, the narrative would be Mr. Watts, did whatever it was that he did. I did this, I did that. Generally, when he allocutes or when a stipulation is written and the parties sign to it. This is a felony case.
Since he didn't allocute and it was only the prosecutor who stated the factual basis of the case, that means that Mr. Watts is agreeing to whatever factual basis that the prosecution puts forward.
Correct.
Yes. Okay, let's continue.
Thank you. So the court is going to accept your guilty pleas to count 1 through 9. The court finds that your guilty pleas are being entered knowingly, intelligently, and voluntarily. And the court is going to continue to have Mr. Watts held without the ability to post bond. I believe that we are currently scheduled for a court date on November 19th at 10:30. I'm not sure how much time the parties need to sentencing heard. I don't have any intentions, given the nature of the crimes that you pled to. There is no need for the court to have a pre-sentence report. So does November 19th still work for the parties? If we need more than 90 minutes, I'm available the entire morning. So you tell me how much time you need, and I'll be glad to accommodate that.
Mr. Ren, Your Honor, our request with respect to timing with sentencing hearing will be 2 hours. I anticipate members of the family wishing to address the court, first of all. Second of all, as to the issues of a PSI, the people actually would request the court order a PSI for classification purposes. It's my understanding that the Department of Corrections is benefited by that type of report.
I don't think I can have it by November 19th.
Mr. Ren, it would be our preference if these are the 2 options. We'd rather have the 19th sentencing date and not have the PSI. But if we could have both, we'd rather.
I need about 30 days, or at least 30 days for a PSI, especially with a case of this magnitude. And so I'm sure DRDC will be able to gather information they need to. Is that okay with everybody?
Mr. Walsh, yes, I think that makes more sense, Your Honor. Mr. Ren, that's fine. If that's the position of the probation department, that they don't think they could have one ready by the 19th, we will live with that.
I haven't specifically asked them about that. Would you like me to obviously make a request?
Mr. Ren, I'll leave it up to the court.
Mr. Walsh?
I think it makes most sense to do it at the RDC, considering the nature of the plea here and the sentencing hearing.
Okay, so we're scheduled for 10:30 until noon. You would like to get started earlier if you'd need 2 hours.
Mr. Ren, yes, please.
Okay, do you want to start at 10 o'clock or a little bit more than 2 hours?
Mr. Ren, 10 o'clock is fine.
Is that okay with you, Mr. Walsh?
Yes, Your Honor.
Okay, so we're going to continue this matter for sentencing hearing on November 19th at 10 o'clock for 2 hours. My understanding is there is no other courtrooms available that are bigger than this one. So we'll try to accommodate members of the community if they want to be here for sentencing. I believe Division 16 may be available. We're going to try to have live streaming in Division 16 for overflow traffic, since this courtroom may not be big enough. Okay, are there any other questions, any other issues, Mr. Rourke, Mr. Wren, Mr. Roche? What would you like me to discuss today?
Nothing from the people, thank you.
Mr. Walsh?
No.
All right, we'll be back in recess. We'll see you November 19th, 10 o'clock in the morning. We are in recess.
Proceedings concluded. So sorry, we haven't been looking at chat, but we're ready to take questions now. And any reactions that you have now that you've heard the plea hearing and what took place in the courtroom. But as you would have seen, the judge was quite thorough, and the key word in the end is that the plea was entered into voluntarily, intelligibly and knowingly. And these are the three main criteria for the judge to be able to accept his plea, and making sure that he appreciated and understood the nature of the charges, and also the minimum sentencing, that he will be serving life in prison without parole. And he went through each charge, and Chris Watts stated guilty to all 9 counts. And he also went through his satisfaction with his counsel, and this will then probably bar his 35-seat challenge of ineffective assistance of counsel, since this is all taken into the record. And do you have anything to add, Eric? And I'll take a look at chat now. And if you've asked questions earlier that we've missed, feel free to shoot them again.
I think the record is clear in that it's what I like to call essentially kind of like a script. It's kind of, you can visualize what's going on in the courtroom just by reading the transcript. And it's a lot of procedure, but I could understand that one individual had made a comment that the court was so small that there was people that probably did not want to be within the vicinity of Mr. Watts, but it's a courtroom. Everybody has the right to due process, and we're also availed to open courts. So this is an open court hearing, and that's what reporters are there for, and also family and members of the community. These are the type of factors and things that other people may not come up with, but in terms of your post-conviction relief, essentially we've laid out in the transcript all of the facts and evidence that's necessary to overcome any kind of ability to make that claim. He unfortunately kind of did away with that by taking the plea agreement, but that's one of the benefits of the bargain, is that you waive all these rights before you take the plea. And the plea, essentially, in this particular case, the maximum, which is the most important part here, is the death penalty. And obviously there are minimums, there's maximums and minimums, and the maximum here is paramount. I mean, this is the man's life. And so he was abundantly made clear that had he taken this to trial, should the state request the maximum penalty, they, by law, had the ability to enforce it if he was found guilty. And they did fine for that type of sentence.
Eric, we actually have, so Shakespeare's sister actually asked this before and is asking again, if you're a Colorado defense attorney, would you have taken this case?
Me personally? Is that the question?
Yes.
I've been asked job interviews before in the past, what kind of cases you aren't willing to take. And one of my mentors, I asked him, so it'll dovetail the same kind of answer. Would you be willing to take a death penalty case? And the real issue here is, what's at stake here? What can end up happening to this individual who you're representing? And the problem is that the individual may end up losing their life. So would I take the case? I'd be very hesitant to, because of the outcome, the potential outcome. It's I've worked in jurisdictions and in cases where death penalty was not on the table, even homicides or attempted homicides. So it's a tough case. It's if you believe your client's innocence and you take it to trial and you lose, the maximum sentence is a potential for the death penalty. And then if the individual, it's a difficult case. It's a difficult situation. I understand though, Mr. Watson, he received the benefit of the bargain, but one of the benefits of the bargain is he has no appeal rights, no post-conviction rights, but he does evade the death penalty.
And I'll circle back to our discussion on the death penalty a little bit, simply because Colorado hasn't imposed it in a very long time in terms of, as a practical matter, as to whether or not he did receive a bargain. And so we'll circle back to that. But we have a question. So the interesting thing about this case is that Mr. Watt's parents later on did receive recognition as victims because of their grandchildren's death, because they lost their grandchildren. And there was a discussion at the plea hearing that the victims were present, and that is the Rusak's family, Shanann's family, and that they were in agreement with the plea. Now, later on, so the question, I put it on the screen, that, we read part of the transcript that the victims were in agreement with the plea, but the Watts were later considered victims as well. Does this change anything? I mean, it's quite a particular situation because the Watts, they're grandparents of the deceased, but they're also the parents of the defendant.
Well, they're also family, and in the domestic violence cases that I've represented, or at least was involved in, there's always been some kind of statutory provision, and I don't have the transcript in front of me right now, but there was a statute that was alluded to, an act, and I don't know whether it was federal or state. I haven't taken a look at that. But
it was a state act. Yeah, this is a state case.
So, and there's a question about what is a PSI, pre-sentence investigation or pre-sentence investigation report, but we'll get to that in a second. So the act actually is enabled by the legislature, signed by the governor generally, and then it basically emboldens or empowers individuals for, well, in terms of legislative acts, anything, but in this particular case, signifying to individuals that they have certain rights. And in this state case right, victims can also include family members that have, for example, if this was a misdemeanor or a minor felony domestic violence case, the parents might be victims too. I don't know the language of the statute, but it encompasses kind of the familiar relation here. There's a reason why this gets amplified, particularly as a domestic violence cases, because these individuals aren't strangers. Mr. Watts knew the decedents. This was his wife and his children, and it extends past that. But more importantly, the law understands and identifies that these individuals were domestic individuals in terms of the familiar relation. And then yes, the grandparents are part of this. The grandparents are victims too. They lost the relationship to their daughter and their grandchildren. So
no, I mean their daughter-in-law, but they hated their daughter-in-law. So
well, regardless, they did lose their grandchildren, and I'm pretty sure they
yes, but the fact that the plea agreement, was not, they didn't receive any consultation for the plea agreement. Is that, I know you're okay. This has to be highly caveat in answering this question, though, because you haven't looked at the Victims' Rights Act, and you haven't studied this issue. So I don't know how much you can answer this, based on your practice, but the Rusak's family were there at the plea hearing. The Watts family later on applied for victim status recognition in the sense that they were able to give a victim impact statement at the court. Yeah,
and that's definitely something that's within the purview of the court, making statements. letters of support, letters of, victim support. But once again, that's up to the statutory language. And I know, at least in terms of the statutes that I work with, the language is very specific on who is a victim, who is the domestic qualifiers here. Now, if he had assaulted his own parents, then, this would be a different type of case, but they're trying to apply as victims under the statute. I don't know the statute, and so I'm not going to presuppose what they qualify for, or whether the judge would be able to find whether they qualify for that status.
This maybe this may be a question we'll have to park for another live, because I'm sure Eric will come back to do more lives with us, since there's so many questions to be addressed by a defense lawyer. I'm sure Eric will be back if we're nice to him.
So long as I could have my cup of coffee,
yes, your tea and coffee. So okay, so there's more questions about. Well, you heard the Chris Watt's own words. So there's questions about who initiated the plea. Well, we only heard you heard Chris's prison interview, but he indicated that he told the truth to his defense lawyers because he didn't want them to lie for him. I thought that his answer, in my personal opinion, was quite self-serving, because he said almost as he was sacrificing for everybody by ending it all, rather than I pled guilty because I'm guilty. Yeah. So he was trying to say, I'm saving everybody from pain, ending the nightmare. And I told my attorneys the truth because I didn't want them to lie for me and look foolish. It sounded very, oh, what a noble, sacrificial thing to do, to plead guilty and save everybody else. What a martyr. And so the question is, who initiated the plea? But in your practice, at the end of the day, I mean, the attorney can't make a defendant plead guilty, right? I mean, you've handled tons of guilty pleas.
Absolutely not. I cannot implore a client to take a plea or force them to. In fact, that was in the language of the transcript. Nobody has forced you or threatened you or coerced you other than this plea agreement offer. I think, I'm not sure, I'd hate to have to refer to pop culture, but, we've seen criminal defense attorneys in movies, plead with their clients, yes.
Hold on. I have to take a quick break, but please continue answering the question.
Sure. The plea agreement eliminates all options other than the one that you're receiving. And, the person may plead innocent later tomorrow, but by pleading guilty, they waived all of those rights intelligently, willingly and knowingly. And so, if there is somebody else, another defendant, if there is other people culpable, and the state makes an agreement with that defendant, that it closes the investigation. It really kind of puts the burden on that one defendant. And so if they turn around and say, well, I was factually innocent, and I didn't want to do it for this reason and that reason, well, maybe you should have brought that up. Speak now or forever hold your peace. And so that was abundantly clear at the plea hearing, essentially. I mean, the judge asks him numerous times, are you, do you know what you're doing? Have you been advised properly? Has all of your rights been explained? The discovery, the case files, all your options, essentially. Every single one of them should have been exhausted with you. As outlandish as it may be, in my practice, I've explored what I can with my clients. Everything I could possibly think of before moving on to a plea agreement. And if the plea agreement sounds reasonable, if it's something that my client wants to take, that it's their decision alone. And in Mr. Watts' position, if he wants to plead guilty to get it over with, then he's taking the burden, the responsibility of the punishment for it. And it's self-serving, yes, as one individual made a comment on, and it's difficult to have to stomach, but like I said earlier, you can't unring that bell. It's a situation where you've pled guilty. There was a factual basis. It fits the timeline of the crime, and as far as law enforcement is concerned, case closed. So
at the end of the day, it has to come from him, and I am sure if the attorneys were the attorneys would have to protect themselves, given that he was pleading so early in the case prior to the preliminary hearing, that if I were in the shoes of the public defenders, I would probably have memos written out of possible legal strategies just to cover myself in case there's any later questions and there's a waiver of attorney-client privilege. I would probably be writing out memos of possible legal defenses, etc., and Chris taking the guilty plea that he was properly advised.
In an essence, he's waiving all of those rights. He may be even waiving privilege. I mean, he's already discussing what he's discussed with his attorneys. The judge asks him outwardly, did you talk to your attorneys about these things? Yeah, absolutely. He says it on the record. He waives his Gideon right. He waives his Fifth Amendment right, his Sixth Amendment right. He says to the judge that, and he also waives his Fourth Amendment right if there have been any motions to suppress or dismiss charges, in hindsight. He waives all those rights when he takes the plea. And people have to understand that. And there's some talks about mental incompetence or,
yeah, so there's capacity. A question right there for you.
Yeah, that once again, that is an issue that should have been addressed back then. He can't be mentally incompetent after the fact. He needs to be mentally incompetent, before his plea, or if not at the time of, of the crime. It's difficult for someone to have to caliber somebody who is mentally competent very closely to that act before or after, and then have to present a case in retrospect about whether they were mentally incompetent at the time. That's something that should have been recognized, and I'm not going to say it's clear as day, but
also
bring that up muddies the waters.
If there was a mental incompetency issue, then the plea of not guilty by reason of insanity would have been considered at that time. If that was on the table, I think that would have been something that would have been considered. But I think that by the judge of everything, and even in the discovery, you can see his prison log between the 16th and the 20th of September. He was monitored daily, and he had medical exams and all of that, and he seemed perfectly fine. It's quite a high threshold, and now he can't claim mental competency 3 years later. How are you going to evaluate him 3 years? Judge him 3 years from before. I mean, his demeanor in court had to be judged by Judge Kopkow, who had to be satisfied that he was competent when he was answering those questions for the entire duration of the hearing.
And that's where the judge would rely heavily on counsel. Defense counsel has these sit-down meetings with their clients. They're the ones that are first and foremost the ones that will be talking to the defendant and saying, do you understand what I'm saying? Am I talking gibberish to you? Do you need help? So, usually if this is an issue, it would generally be caught very, very early. You need to start setting the groundwork. And to claim incompetence, but without having any factual basis or evidence to support your petition is disingenuous, at least to the court. And so his defense counsel proffered to the court that this man was intelligent, he had capacity, he knew what he was doing, and more importantly, he was willing to take the plea agreement. So once again, he's waived all those rights, and there's nothing in the file that indicates that he has an issue of incompetence. Nothing at birth to the time he took plea, and then any time between then until he files this Rule 35 issue. So, you know, it's not there. In other words, he's making up out of almost thin cloth, and it doesn't help him. It would have helped him, you know, 4 years ago at least, but that's kind of not where we're at today.
Not to mention that mental incompetency is not a ground for a 35C or after the fact.
No, it's not. That's a different type of issue. It's an issue of, you know, did you understand the charges against you? You know, because can you be restored is another issue. Can you be restored to mental competency? You know, or and it happens to a lot of defendants where they can or cannot. And if they can't, then, you know, they're in a hospital until, you know, they may be hopefully return to competency. But, you know, Chris Watts, very clear as a bell. And, you know, in all of the body cam videos, all the interview rooms, all of the discussions with him in and out of court, he seemed pretty competent, at least to me. And I'm not a psychologist, so I'm not going to proffer that I had a clinical relationship with him. But, you know, there are usually those little telltale signs that some person had some kind of mental illness that may have impacted their ability to defend themselves.
Oh, I think we have the same question again, so we're just going to answer it very quickly about because this is constantly being brought by the Watts family, and it's a narrative that is going on so much in YouTube. And a lot of the narrative right now, and I think it's really so much misinformation because it's disinformation, and there's no attorneys really speaking on the issues, and a lot of people are not really versed in the legal system, or there's a lot of people interpreting the law who are not lawyers. So it's leading to so much rumors and fake news, and this is why we want to keep this series really fact-based. And so I just posted a question again. Cindy is Chris Watts' mother, whom I mentioned, who wrote ex parte to the judge, and you saw some of her phone call when I showed it to you, that she really wanted him to fight, and she's still in denial until today, I believe, because she says she wants to know the truth, even though he told the FBI what happened at the prison interview that I showed parts of it to you. And there's been various anecdotes that he has already confessed to his family. They went over to Wisconsin, and he has told them the truth many times. But do you want to answer that again about?
What was the question? I'm sorry, Nina.
It's up on the screen. I mean, the attorney doesn't owe his family any duty, and the attorney is there to protect him from speaking to anyone else outside of counsel, because it can jeopardize the case. So it is standard practice in any case where the defendant is in custody not to speak to anybody but his lawyer. And that order, mind you, while it was in court, was to prevent the investigators from trying to talk to Chris Watts or the DA or any part of law enforcement from trying to have discussions with Chris Watts as well.
Right. And just to kind of touch up on that question, the defense attorney has a duty to their client and an exclusive duty to the client. If their duty is spread between that client and another client who's
or the
direct
parents,
opposition,
or the parents, they don't have a duty to the parents.
I will open the scope up in a second, but that's called the conflict. And obviously you're conflicted out of representing either their client or both clients. It depends. I've been in a lot of those type of situations. I've also gotten phone calls from mothers, from parents, grandparents, even saying, well, can you tell me about the case? Can you tell me what he said? And that's privilege. Privilege and confidential. And I tell my clients that up and down. I cannot repeat what you say to me. It's important that they know that. There has to be a level of responsibility on the defense attorney, and more importantly, that there's a trust that a client has in their attorney. And I always say attorneys have two powers that everybody else also that doesn't have. They have the ability to give legal advice, like, in case there's somebody in front of me and I need to discuss with them their options, their legal options, and then step in their shoes, for the people, for the defense. The person doesn't speak, particularly Watts won't speak because he's going to give up his Fifth Amendment rights. So he stands there mute while the attorneys speak for them. So that way he doesn't give up that Fifth Amendment right. Now, to have this discussion with the parents or, about the case starts to kind of, muddy that water, and then things start to get murky, and you don't want to have conflicts, and that's the reason why I brought up the conflict with the direct conflict first, is because the parents trying to insert themselves into the case may cause issues, may cause direct conflicts. And more importantly, if you're talking to the parents aren't the clients. And if they know something and then get subpoenaed by the prosecution, they've become witnesses for the prosecution now. And you've essentially shot your client in the foot for him. So, you have to be very careful about what you say to whom when it comes to a case file like that. And bad things can happen. And so I will leave it at that. And I think that the defense attorneys did the best they could considering the circumstances. And more importantly, they saved Mr. Watts from the death penalty. I know things changed, but that's capital punishment.
You have a comment for you right there.
I have not heard a cup of coffee in probably like an hour, so I'm done drinking coffee. I feel amplified. I'm good.
Good. You're on a roll now. So let's go through the actual guilty plea just now, just so we can give an entire global view of really what happened with the plea, and then what Chris ended up signing. And you can comment on if this is the usual type of guilty plea that you normally handle with your clients. So I'm sharing this screen with you right now. Eric, can you see it?
I can.
Okay, so do you want to read it out loud?
Sure. This is a standard written waiver and guilty plea. Essentially, these documents are stipulations essentially that give the opportunity for parties to save the court some time instead of having to have the client admit to certain facts on the record. This gets incorporated into the record. It's filed with the record and it said something at the top right-hand corner of like which document it was filed under. This wasn't a long-standing case, so there weren't a lot of documents that were filed. It just says the date filed and not the number.
It was
federal
on
court,
the same.
usually,
it was the same day as the plea hearing, so it was signed on that date.
Yeah. Right. So, and there were no motions hearings in this case, so there weren't any exhibits or, notices filed with the court. So, this is probably one of the few documents that were actually filed with the court. But I'll just get to the document.
No,
Number
the
one.
defense attorney actually filed about 46 motions. They were busy. So, I mean, the other rumor
Okay.
that I've seen on social media that Chris was left to hang dry and, he was in a hole and all that. We'll discuss that in a little bit. But, it is actually, I mean, he's public defenders were working really hard for him.
Yeah, I understand, but I don't think they had any intention of following through with those motions. I believe Chris Watts had thrown in the towel at that point and was quick to plead guilty to these charges.
He said
by
September he wanted it all to end.
I'll just get to the document. Number one, I am the defendant in this case. I have had enough time to talk to my lawyer about this case. She has discussed the evidence against me. I'm fully explained my side to him, her. I believe the district attorney has enough evidence to convict me at trial. I'm satisfied with my plea agreement in this case is in my best interest. Number five, I understand that I have the right to exercise any of the following rights, even against my lawyer's advice. A, the right to remain silent about this case, the right to have my lawyer represent me and be present with me during any conferences or questioning by anyone about this case or at all court hearings and at trial. The right to plead not guilty and have a jury trial, and the right to appeal my case to a higher court if I am convicted at trial. 6, I understand that the right to a jury trial includes A, the right to help select the jury, B, the right to confront witnesses to testify against me, and to have my lawyer cross-examine them about their testimony. C, the right to be presumed innocent unless and until district attorney proves my guilt beyond a reasonable doubt. D, the right to have my lawyer call witnesses to testify for me if I want, and if necessary, to have the judge order witnesses to come to court. 7, I have read and understand elements of the charges that I have pleaded guilty to, as shown in an attached sheet. 8, I have read and understand the possible penalties that I could be sentenced to, which are shown on the attached sheet. 9, the plea is freely, intelligently, and voluntarily given. I know that I'm giving up all the rights that's described above. I understand these rights. I'm giving up these rights and pleading guilty of my own free will. No one presumed me to try to make me plead. Pressured me. I'm sorry. This is all just very bad scanning here. No one has pressured me or tried to make me plead guilty against my will. I have not decided to plead guilty because of anything I have been told except for the agreements shown on the attached sheet. 10, I understand that the record may be further supplemented by police reports, affidavits, or other documentation attached or provided at the time of sentencing. 11, I understand that if I am not a citizen of the United States, that the guilty plea may cause collateral consequences, including not limited to deportation, exclusion from the mission to the United States, or denial of naturalization. 12, I understand that the following sentencing in this matter, I have, in certain circumstances, the right to appeal, review of my conviction and sentence. A notice of appeal must be filed within 7 weeks or 49 days of the sentence. I also understand that if I am determined indigent by the court, that I have the right to the assistance of appointed counsel upon the review of my conviction and sentence, and the right to obtain a record on appeal without payment of costs. Additionally, I understand that I may have the right to seek post-conviction reduction of my sentence in the trial court within 18 weeks or 126 days of the imposition of sentence pursuant to Criminal Procedure 35B. 13, I have read the form and understand my lawyer has answered all of my questions to my satisfaction. Signed, the defendant. And then the 14th line is I represent blah, blah, blah.
Yes, and I mean, the rest is basically
There's actually a provision in here that's omitted, and that is that the jury has no right to presume that I'm guilty, or that if I don't testify in my own defense, that I am also presumed guilty.
Yeah, so the rest is basically all the charges that he's pleading guilty to, and that's that. So that is his guilty plea, and the penalties are listed. So he is pleading to life without parole. So that is basically what the hearing was about, and what he had signed. And I think this explains the 35C, hopefully in a more cohesive manner. And Eric and I, should we answer the question at the same time? Can Chris get a new trial? 1, 2, 3?
No.
No.
Sorry.
No.
It's
Crystal
highly
clear.
unlikely not, as I'd like to.
It's not going to happen. He's going to spend the rest of his time in Dodge.
Yeah, it's unfortunate to have to say that he has no opportunity to reopen this case and relitigate it, because there are a lot of people who are, requesting answers, and unfortunately, only he knows the answers. And at this point, there's no other evidence. There was a question about the PSIR. I'm not sure if you're going to leave that for another day. It's a very involved question that both the states and the federal government proceed in before sentencing generally, and time is required to have a pre-sentence investigation report drafted in an interview with the defendant, essentially off the record, and kind of like a report given to the judge. But that's going to be my quick answer, and I'm not sure if you would want to get more involved answer than that. But essentially, it kind of gives the judge a heads up of the person's background, their poverty, their upbringing, their education, their criminal history, which is huge, particularly in the federal criminal justice system, particularly as applied to the sentencing guidelines. In other words, the more heavier criminal history is, the more heavy they're gonna. I like to call it guerrilla math, and it's just, you've got a couple of felonies in the federal system, you are looking at significant amounts of time, depending on what kind of charge you've been alleged to have committed.
There's one of the clause in the 35C about if there was new evidence or material fact that was not presented to the defendant. But here, that's not really the case, because it wasn't a trial. So, I mean, it has to be evidence that Chris Watts didn't know about.
Yeah, that happens much earlier before then plea happens and sentencing happens. There's a question of who gets to request a plea offer first, and it happens both ways. Sometimes the disclosure or discovery, in other words, all of the evidence that the state has, dash cams, body cam videos, DNA, photos, computer and telephone logs, all of that stuff is handed over by rule, and under law, of course, Brady and Giglio. And if you violate that rule, then you could be in a situation where, yes, you could apply for a 35 and say that the state was withholding evidence that could have helped my case, or could have at least assisted in my exoneration of the case. But that wasn't really present. And I have no I have no indication in the record here that any of this had happened and that he has that kind of claim. I mean, Mr. Watt, that is.
So, okay, I'm looking at one of, I'm trying to find some of the questions. Okay, so some YouTube creators think he has a case if he himself finds new evidence that quote unquote he didn't know about.
Once again, it has to fall underneath certain categories. Yeah.
I'm going to open up that particular section of the 35C again, just so that you can take a look at it before you comment.
Well,
hold on.
It's a general issue of new evidence. Is the evidence really going to tip that scale?
Here.
And it'll be up to the district court judge.
Here. Eric, read number 4.
Yeah, that there exists evidence of material facts not therefore presented and heard, which by the exercise of reasonable diligence could not have been known to or learned by the defendant or his attorney prior to the submission of the issues to the court or jury, and which requires vacation of the conviction or sentence in the interest of justice. It's a heavy lift. It's a very heavy lift.
This is if evidence that Chris Watts didn't know about against him. Okay. No, yeah. Exculpatory evidence. So I'm sorry. I mean, this is going to be very difficult. And I have to say, just because a YouTube creator says something doesn't mean that it's true.
There would have to be evidence, period. There has to be a petition to the court, and then the court has to see that the petition references something, new evidence, period, discovery, disclosure, anything that says, by the way, I wasn't the guy, I didn't do it, then this is the reason why. Prima facie case, essentially, in opposition. We don't see any of that. We don't see anything new. We don't see anything that changes the result of this case. And he's outwardly has marked on the record that he was the guy. This has all happened the way he stated it on the record. By pleading guilty, he gives up all of those rights. And yes, he understood that at the time, and
when he
just follows through.
Pled guilty. He pled guilty as a matter of fact and as a matter of law that he committed the crime. And this cannot be understated. That is, both as a matter of fact, he did it. And as a matter of law, he did it. He committed all 3 murders.
He did. We don't have a videotape of him doing any of this stuff, but unfortunately that's not the purview of the court. And in this particular case, it's not.
I mean, what we have is
everything else.
The video cam of him loading the truck, and this is a subject to debate, but we have his GPS of him driving straight to the oil site 319 where the bodies were found, and him locating where the bodies are.
Right. And we're essentially diving into detail of a case that's already closed and admitted to by the criminal defendant. So as lawyers, we don't review the case under those circumstances. I understand that people may have difference of opinions, but as a matter of law and a matter of fact, that it's Mr. Has already admitted to all of these crimes and exactly the way it happened. So, that's what happens when he signs this plea agreement.
Okay, so I mean, some say he should get a 35C based on ineffective assistance of counsel because he was denied due process and had rights taken away. So can you answer that? I mean, now that we have gone through the plea hearing transcript that he has confirmed.
Right. Due process of law is, it's extrapolated in if which he gave up. If there is due process, there was due process. There was an opportunity for him to be heard. There was notice and a hearing. He was given notice, a summons essentially and a complaint. And the complaint indicated that he had committed these crimes. And he shows up to court, and after discussions with his attorneys, he decided on his own accord to waive all of those due process rights. He said to himself, I don't want to do any of these things. I want to, I've gone to the Vegas buffet, I'm eating this whole thing. And he has every right to do that, every right. And so, not only in the interest of justice, but also the interest of his own self-preservation, he took this plea agreement. He also agrees in his plea petition that there were sufficient facts to be found against him should they have taken this to trial. And they would have convicted him of this crime in his own words, because he signed that document, the waiver and plea of guilty. That's what he's signing to. And granted, like I said, the provision that was omitted was that he doesn't have to say anything. And that's part of his due process rights, but he did. And he pled guilty in front of a judge. Those are his due process rights. And he waived them. And so that's why he puts himself in this position.
Yes, it's not like he had a trial and then there were due process violations throughout his hearings. But in this case, when you plead guilty, it really complicates the 35C. I mean, 35Cs aren't usually filed when there's a guilty plea. When you plead guilty, you give up all of these rights. And
Correct.
The plea hearing transcript, when the judge had a long colloquy about his satisfaction with his counsel, whether or not his counsel advised him of everything, whether or not his counsel explored all the legal options, the legal alternatives about going to trial, etc. Could his counsel have done anything differently? Was he fully satisfied with his counsel? The judge asked questions about the effective assistance of counsel on the record in 10 different ways. So if he's going to try to challenge on ineffective of counsel back to the same judge, the judge will just go back to the record and look at his answers to the same judge's questions about how satisfied he was with the counsel. And
Correct.
Whatever happened prior to his plea is neither here nor there. Just as people talking about his first or second confession, none of it really matters. What he said in his first confession, what he said in his prison interview, which story he wants to pick, it's neither here nor there. He pled guilty, and that's the only thing that matters.
I think that
as a matter of law, in the eyes of the
correct.
Court, that is.
Correct. And I think individuals may feel frustrated by the fact that he's pled guilty and now he is remorseful about what he has done to himself, despite the fact that at the time he found, that this is what he did. This is what he admitted to. I mean, there are a lot of people who don't plead guilty, that they take it to trial and they end up on death row and they appeal their case. And some states haven't had death penalties in long time, because death penalty appeals take a long time. And so long as you keep fighting your case, you have an opportunity to continue your due process rights. And for Mr. Watts as a young man, I mean, he has plenty of time. And granted, he made that calculation for himself. So the benefit of the bargain was something that he had to think about, and I'm pretty sure he had a team of attorneys to discuss this with and say, what's in my best interest here, even if it meant that he would find himself potentially in a death penalty sentencing. They had to discuss this with him. Is it worth it?
So
they
there's
would also
one of the
say,
issues that there was the garbage bags that were near the crime scene. There were some fingerprints that didn't match him or Shanann. But that was all taken into consideration because he was asked specifically that he went through all of the discovery with him, with his defense counsel, and he still chose to plead guilty.
Yeah, that's that.
No, it's not.
That is an
it
issue.
Can't be that he wasn't aware. He's not allowed to plead guilty without having the full discovery.
Correct, and that is part of the file. That is discovery that defense counsel would have reviewed with him. They definitely and should have said, we have this video footage, we have this, colloquy you had with the police, and you say a different story later on, and then, your parents are talking, and then, now we have these fingerprints. They have all of these things. Obviously, everyone else started getting copies of it later on, but there should have been the ability to review all of these things before walking into a plea agreement. But the plea agreement is something that's been discussed amongst counsel and client at length, and it's a tough sleep to have to wake up the next morning and make this decision, but it's something that a defense attorney and their client must cross. And so hopefully, in the purview of the defense attorney, at least at the time, they saved their client's life, and Mr. Watts had avoided the death penalty, but to the bargain of pleading guilty. And we can't comment as to say whether he's factually guilty or not, because he's already admitted to it. He has openly and intelligently and willingly given his guilty plea to the judge. And that's his decision. He has that absolute right. So nobody can take that away from him.
So Eric, he pled guilty on the 19th of November, and then he was sent off to Dodge. And the FBI, the CBI, the Colorado Bureau of Investigation, and the Frederick Police Department, all the lead detectives, they talked about how the clock was stopped. Everything happened so fast because he pled guilty. He confessed on the 15th of August, 2 days after the murder, and then he was whisked off to the Colorado prison, and then he pled guilty immediately, and they were preparing for a 4-year trial, and the government paid for the FBI, the CBI, and the Frederick law enforcement officer to fly to Dodge Correctional Facilities in Wisconsin to interview him. And one thing is that DA Rourke always promised Rusek that he will get them the answers as to what happened, because Chris didn't allocute and he didn't say anything as to how the crimes happened. So he always promised Rusek that he would get answers. But the officers also went there saying that they also needed closure for themselves. Now, do you think there's any other reasons they would go there? At one point, I thought that maybe they wanted to know if there were any other suspects or if he would flip on anybody. That's a possibility. But I think that this is a case that really took an emotional toll on law enforcement. Detective Baumhofer, who was the lead detective, had to eventually take time off for PTSD because he was there extracting the girl's body from the oil tanks.
Yeah. Yeah, I think I think one of the major issues here, and is one of the reasons why I had such a difficult case with this file, was that there was 2 children involved here, at least, live children, and it's tough. It's really saddening to hear these type of situations. I've been practicing criminal law for quite some time, and this is one of the issues that gets raised every once in a while, particularly as it comes to children, and the safety of children. And I hold those paramount. And to be on the front lines, like police officers and other investigators, for that matter, and then have to review, file after file of kind of just heart-wrenching evidence. It's difficult, but it doesn't distract from the process, and it shouldn't. We want to get to, this individual's rights, and the rights should lead to the correct decisions. Was Chris Watts guilty of all this? Yes, absolutely. How we know is he admitted to it, and the facts support it. And so I'm not going to say 1 and 1 is 2, but could you imagine if, this went to trial and he was found acquitted? I posed that to the panel. It would have been shocking to a lot of people, particularly as a lot of the other information would have, proliferated out of the case. It just, it would have been it would have been an even more interesting case. But what we know here is that an individual, father of children and spouse, was arrested and found guilty of a heinous crime. And how they got there was that he pled guilty to it, and that's how we know.
Okay, I have a question for you there. And we discussed this, that only 2,000 pages of the discovery was released, but clearly, there's got to be at least like 20,000 pages, because you can see in some of the pages of the discovery, such as the phone record search, there's all these zip file attachments that's not released to the public. And there's also a number of third-party requests that are under court seal. And I'm going to take a quick break, but can you explain about discovery that's released to the public? And, and let's be mindful that the discovery available at that time was only the beginning of the investigation, because we weren't even at the preliminary hearing stage yet. And why is the public not entitled to everything in the case?
Several reasons. I know in federal cases, we sign protection orders. In other words, they're only capable or willing to give certain portions of discovery because, for example, it may affect another case or crime. There might be ongoing investigations. And I'm not triggering anybody and thinking that there is an ongoing investigation in this case. But another issue is privacy to the family or to the children or to anything that may lead to that. So, and there may be litigation. I don't know. There are a lot of reasons why state agencies will seal evidence. It happens a lot. And short of a FOIA, Freedom of Information Act request, or a discovery request, if you were a party, or if there was an ancillary discovery request in a civil context, you may not see everything unless you really pry it out of their hands. So sometimes it's not in the benefit of the public to receive these type of documents. There are attorneys who have files and files and files and files of clients that need to have those documents destroyed at the end of their representation, because it's their file. And as long as they have a copy of their file, it's in the the custody of the individual holding that file, and more importantly, they need to be able to hold and protect it. So, you know, there's plenty of reasons why some of these items are not released to the public, and you could just alliterate at end why they wouldn't give away everything. It gets sensitive, you know, on one way or another. There are a lot of issues that throw up the red flags. But I think there is a significant amount of discovery that was released for a case that never even got past preliminary hearing, let alone motion practice. Nina, are you still there?
Yes, I am. And not to mention that there's also a lot of confidential information in the discovery as well.
Privacy, right. Absolutely.
Okay, let's see. Do we have any other questions? If I've missed a question before, you can please shoot them again, because I may have missed it while reading the transcript. Yes, during the prison interview, I think there were several questions trying to allude to whether or not the mistress had a role. But Chris didn't seem to flip on the mistress.
Was that a question or?
I think so. It was a comment. Yes, he didn't really give an answer. It was a comment.
Oh, you know, there are cases where co-conspirators or co-defendants, you know, are pitted against each other, henceforth the conflict rules, you know, but when one individual is not willing to participate, then, you know, there's, you know, you're not going to be able to venture any further. And then, you know, it's really up to that individual, you know.
So you've mentioned that sometimes you've had clients who pled guilty to the statutory minimum sentence. So in this case, they're not really getting a bargain. And in this case, okay, so Chris, the death penalty was taken off the table, and as a matter of practice, the death penalty hasn't been imposed in Colorado for several decades. So the reality of him being actually executed is slim to none. Now, what is the benefit of the death penalty taking off the table? I mean, of him being now in general population versus death row?
Well,
can you speak on that?
Yeah, absolutely. I think it's important to take a look at the case at the time. At the time, he was looking at the death penalty. And if the governor or who the powers may be expedited the process, they would have executed him. And that would have been a very short life for him. You know, you have to understand that walking into a lawyer's office when they're discussing these issues. I mean, if the state finds you guilty or finds you guilty, and the state finds you to be put on death row, there's a distinct possibility you may be executed. But he saved his own life by pleading guilty and getting the benefit of the bargain. And the benefit of the bargain here is he isn't on death row, regardless of the circumstances that are outside, you know, sentencing in Colorado. I mean, remember, death row is still an option in federal jurisdiction, and so they may be able to still. I think they've executed several individuals in federal jurisdiction as of last year, and that hadn't happened for some time. So, you know, that is a very sensitive subject that needs to be handled with kid gloves. You need to be very careful when it comes to somebody's life, when it comes to the criminal justice system. So the benefit of the bargain was that he was taken off the opportunity to be found guilty and sentenced to death row and executed by the state. That screams a benefit to me as a defense attorney and as just a human being in general.
But what about the conditions in prison?
Before he was found guilty and sentenced, he would be in pretrial detention.
No, I'm
once
talking
again,
about, say, being a death row inmate versus being in Gen Pop.
Well, like I said, before getting to his actual sentence,
After. After.
Just one and then the other. What I'm trying to say is that, generally individuals are allotted bond and or bail. And bail obviously is the cash money, $10,000 post 10%, which is $1,000 to the court. They usually reserve that for fines and fees. And, if you flee jurisdiction, you may be on the hook for $10,000. In Mr. Watts' case, he is alleged to have murdered 3-4 people at this point. And so, they kept him in pretrial detention. He wasn't guilty. He just was a flight risk. If anything, harm to society, public safety issue. So they had to hang on to him. Now, one of the options I'm sure he probably discussed with his defense attorneys is if I'm found guilty, what's the difference with me being in general population and found guilty with no death penalty, or I'm found guilty on with the death penalty option, and I'm in death penalty corrections. That's obviously another option he had to have a discussion with his attorneys. He chose the former rather than the latter. He never even considered being on death row incarceration. But then again, like we said already, he would have been waiting for himself to be executed by the state, and fortunately, that's not on the table at all.
Mm-hmm.
So another caveat is double jeopardy attaches both ways. If he had been acquitted of or found not guilty in trial, then he would have gone home. But since he pled guilty to these crimes, they can't charge him again and find him guilty under death row. That and Colorado has removed the death penalty from the state provisions. So, either way, he's not going to find himself at the mercy of the state in terms of execution. So, this is death penalty cases are very, very intricate and very difficult. It's one of the reasons why it really takes a team and individuals who are very versed in the world and the League of Criminal Defense, and being able to advise their clients of the proper decisions to take. And Mr. Watts took the correct decision for himself, considering all of the circumstances. He had the intelligence and the knowledge and the will to do what he thought was necessary for himself. He did not want to be on death row. More importantly, he sounded like he wanted to accept responsibility. Had this been a federal case, he'd gotten 3-point deductions from his sentencing guideline, sentencing, and he did not receive the death penalty, which is the most important part. And that was part of the provisions of the plea agreement. So.
Okay, are full discoveries usually released in other cases?
It would depend on who's asking and who is interested. They are case files for the state. Once again, how you go about getting the discovery for your case would probably be either a request from the state while the case is pending or potentially after the fact. And it might be through a FOIA request or freedom of information or ancillary through maybe a civil context, a discovery request, say, in a civil lawsuit of some type or another. It would depend.
And is he sealing documents because of the plea deal? I mean, I don't think it has any bearing on how much discovery is being released.
Who's he?
Chris.
Oh, I don't think he has the capacity to do very much while incarcerated, let alone seal documents. I don't know if there's a statutory provision in Colorado law that allows him to, as a private citizen, let alone a defendant and convicted criminal. Yeah, I don't see how he could do something like that.
Mm-hmm. So he wouldn't be able to seal anything just to protect Nicole Kessinger, for example.
No, I don't. I mean, like I said, it would depend on the circumstances, but not as a private citizen looking out for another individual who may be culpable for other issues. In my experience with individuals who've been incarcerated, they have very, very limited resources. Other than an envelope and a stamp and a pencil and a piece of paper, sometimes they don't have a lot of resources. I mean, there are some individuals who are incarcerated that have access to libraries and computers, and even then, it's monitored by the state. So they will. You have to understand, when you're incarcerated, they watch everything you do, everything and anything, phone conversations, what you bring into the correctional facility. And this includes jail. As fluid as that front door is, they try their best to try to keep things under wraps.
By the way, do you know much about Dodge Correctional Facility?
I do not, unfortunately. I'm not very, I know there's...
Okay. Somebody asked if he got a sweeter deal. I mean, from his statements is that he had a horrible time in Colorado because he was constantly getting death threats and people yelling at him because he was a baby killer. And it's such a notoriety case there. But in Dodge, he seems to be pretty happy and at peace. He has his tablet. He can do Zoom calls. He can send emails. He's working in the kitchen. So he seems to have a much more kosher life there.
He's not free, and that's his punishment. He will be in a correctional facility for the rest of his life. As kosher as somebody may label it, he will never be able to be outside of those walls. That's his sentence.
And we have another question. So we're going to try to wrap up pretty soon. So if anyone has questions, please feel free to ask them now. I think we kind of covered this already, but do you want to just quickly address the question by Loretta again?
So if he chose to do the 35C, they couldn't find him guilty again. And why didn't they let him talk to his family? And why was they so quick to find him guilty without even putting witnesses on the stand? I mean, let's address that last portion. It is very easy for them to. Yes, exactly. There's no work there. There's absolutely no work by the state.
He chose to plead guilty by himself.
There is an opportunity to have trial, and if the defendant does not request trial, then he has given up that opportunity to be heard. And the state has no burden at this point to try their case. Generally, they are, put to their test, and that's beyond a reasonable doubt. I mean, that's a really, really heavy lift. It's the heaviest lift in all jurisprudence. But they didn't need to do that this time. It would have been a very, very long and drawn out process. And the state will take a plea agreement very quickly, and the judge will, agree to the parties' wishes. And in this case, there was a plea offer, and the defense accepted it, and the judge is there to sign the judgment, or at least the order for the judgment. That being said, the Rule 35 would have to be found off the facts. And what are the facts? The facts are, was there any ineffective assistance of counsel? The record would reflect that no, there wasn't, and so they would have to deny him. As a matter of law, they would have to look back at the record, and depending on whether there's anything added, and I can't see anything being added here at this point, the judge would have to deny it, and then the Supreme Court of the state would most likely affirm that decision. I think that'd probably be the end of that. I don't know if that's something that the U.S. Supreme Court would take on cert. Probably not, considering that I can't find any federal issues here. And so they couldn't find him guilty again. That would be a violation of his double jeopardy rights. They already found him guilty. They can't find him guilty again, or withdraw his plea and then find him guilty again and reimpose some kind of a new sentence. That's not how I gather that works. In the federal rules, like I said, of criminal procedure, Rule 35 is a motion for leniency, and that's to downgrade their sentence. So if instead of you're looking at 20 years, you could be looking at 10 or 5 maybe, but that's not this type of case. And so that would be inapplicable to the 35C motion that Mr. Watts or the question was posed.
Oh, yes, the allocution. So this is something a lot of people asked about, because there's a misconception that it is a requirement that the defendant has to state in court exactly what he did, and that has to match with the evidence. But here, as we see from the plea hearing, is that he stipulated to the facts. And so you see the question over there is that I don't think he wanted to speak. In my personal opinion, is that he doesn't want to be seen as a monster, and he doesn't want to go into details as to what he did. But can you comment on that, on the necessity of the allocution?
Not necessary. The judge generally asks the defendant, and if and sometimes they don't, but generally, in my experience, the judge always asks the defendant, do you have anything else you would like to say for yourself? And usually my clients want to move on. They want to go home. They want to pay their fine and end up, being done with it all. And it sounded like he was in the same position. As to an allocution, that's I think probably as far as that will go. But backpedaling to facts that support the plea, it sounds like the parties stipulated. In other words, they wrote down what it was that he was willing to agree to. Outside of that, that's as far as the court needs to go. Now, you have to understand that the court isn't there on either person's side. They're not for the prosecution. They're not there for the defense. They're there to make a decision based off either the parties' agreements or the parties' disagreements. They don't want to make sure that the court, that is, wants to find themselves, jammed between a rock and a hard place. And so by going above and beyond, sometimes they may end up abusing their discretion, which is usually the number one issue on appeals, an abuse of discretion. And so the judge accepted the facts from Mr. Watts that supplemented the allegations that had been pressed against him in the charges, and then that was sufficient to find for a conviction, and then the sentence was essentially what they had set out, life imprisonment, without, of course, the death penalty option.
So I think, Brennan, I think that answers your question, that allocution is not required for a guilty plea. in a murder case. I think we're going to wrap it up unless,
yes, sorry.
because I think we've gone 3 hours now, so we don't want to take too much time unless there's any last minute burning question from anybody.
Hearing none.
No, but hopefully, if everybody can thank Eric, and hopefully he will come back. And we'll go through some of the other aspects of the case, especially, I think, delving into some of the interviews from a defense attorney's perspective, I think would be really interesting, especially given Eric's extensive experience with watching interrogations. I think that would give quite an interesting perspective if you'd like to hear from a defense lawyer. So hopefully you'll stay tuned. And thank you so much for joining. Thank you, Eric. Even though it was early for you, but we very much appreciate you coming on the panel and shedding light from your criminal law experience.
No problem. Thank you. Thank you for having me.
And thank you, everybody in chat. I very much appreciate you joining. If you haven't clicked the like button yet, please do, and feel free to share this live. And if you haven't subscribed, I'd be really grateful if you can subscribe, turn on this notification. We'll try to make lives more frequent, because with all the drama going around, I think it's very important to put out factual information. So we'll make an effort to do that. And thank you for tuning in. And if you didn't catch a whole live, you can always watch replay. So thank you so much. Really appreciate it. Goodbye.
Thank you. You take care. Bye-bye.